The elements of a functional assessment of decision-making capacity are set out under Section 3 of the Mental Capacity Act. Section 3 of the Mental Capacity Act speaks about the inability to make a decision. And subsection 1 says that for the purpose of Section 2, a person is unable to make a decision for himself if he's unable to understand the information relevant to the decision, to retain that information, or to use or weigh that information as part of the process of making a decision. Or, as a separate feature, they're unable to communicate their decision, whether by talking, using sign language, or any other means. Subsection 2 reminds us that a person is not to be regarded as unable to make a decision because they're unable to understand information relevant to decision if they are able to understand an explanation of it given to them in a way that is appropriate to their circumstances, using simple language, visual aids, or other means. It also reminds us that the fact that a person is able to retain the information relevant to a decision for a short period only doesn't necessarily prevent them from being regarded as able to make a decision. It will depend on the decision that needs to be made. Subsection 4 says that information relevant to a decision includes information about the reasonably foreseeable consequences of deciding one way or another, or of failing to make a decision. Reasonably foreseeable consequences of the decisions they make or fail to make. The Code of Practice summarizes Section 3.1 as saying that the first three elements are applied together. Understand information relevant to a decision, retain the information, and use and weigh it. If the person can't do one or more of these things to your satisfaction, on balance, then they lack capacity for that decision. The fourth element, the communication element, only applies where the person can't communicate the decision in any way. We saw that the person has to understand the salient details of a particular decision. And you establish the salient details by using the authority of the common law where they have decided the case. But you have to acknowledge that each case turns on its own facts and that not every element of a decided case might be applicable to your particular assessment. Otherwise, if there isn't a case to which you can turn to for the salient details, the safest approach is to ascertain the facts, apply the statutory principles, and reason a conclusion from that. What are the salient details for this particular novel situation? The second element of the functional test is that the person has to be able to retain information, to hold the information in their mind long enough to be able to use it as part of making a decision. Subsection 3 states that people who can only retain information for a short while mustn't automatically be assumed to lack capacity to decide. It does depend on what's necessary for the decision in question. The Code of Practice again reminds us that this isn't a memory test necessarily, and that items such as notebooks, photographs, posters, videos, and voice recorders can be used by the person to help record and retain information, and can be used by that person to recall information as part of their decision-making process. In a London borough in G, a court was required to determine whether G lacked capacity in a number of respects. The local authority had brought proceedings under the inherent jurisdiction of the court, and it proposed to bring an application under the Mental Capacity Act. G was frail, elderly, and had a number of health problems. She lived in her own home with two carers. She had no family in the United Kingdom. The local authority was seeking to put in place a care package to ensure that she could remain at home safely, and it had been trying to investigate reports that G was being manipulated, influenced and intimidated by the carers. In conducting the assessment, a doctor carried out a Montreal cognitive assessment, and following that the doctor concluded that G could not maintain attention and concentration. She had a low score on delayed recall of 5 words. She was unable to retain information, a necessary part of the function of decision making. The doctor was of the opinion that her score was in keeping with moderate severity dementia, failing on recall tasks and on executive functioning tasks. Both of these required weighing information to come to a valid decision. While past memories may be clear, to make decisions one has to bring past memories and experience forward and apply them to the present, but also to the future because of the reasonably foreseeable consequences requirement of the capacity test. G's ability to do that was seriously compromised by dementia. She was unable to make a decision because she was unable to retain information because of her dementia. More complex decisions, such as who lives with one, require abstract thought and weighing relevant information and experience in the present, and G's ability to do that was also impaired. So she was found to lack capacity. Similarly, in the Westminster and Sykes case, Mrs. Sykes was 89 years old. She had dementia. She currently resided at a nursing home, but had expressed a wish on many occasions to return to her own home, where she'd lived for 60 years. She was intelligent, articulate, and knowledgeable. She had no difficulties expressing herself. Her core personality was intact. She spoke passionately and committedly about her causes, but her short-term memory was very severely impaired. It wasn't immediately apparent from a superficial exchange with her, but assessment showed that her short-term memory was less than a minute. It is this inability to retain information that lay at the root of many of her recent difficulties. The consequence was that she was unable to retain, nor therefore weigh, information relevant to a decision about the treatment, care and support she requires. The inability to decide has to be because of the impairment or disturbance to the functioning of the mind or brain. That link has to be demonstrated. And in this case in particular, it was demonstrated that she couldn't recall the circumstances and behaviour that caused others to remove her from her own home to hospital and then transfer her to the nursing home. Lacking that information, she didn't accept that she had a significant problem at home, nor therefore that she required a significant package of care and support. Nor could she appreciate that without additional care, it was likely that the problems will be the same as they were before, because the situation is the same as before. It is recorded that she has a tendency to become defiant when these issues are raised, and that's logical and understandable, because unless one has memory of the previous difficulties, the professional view must appear patronising and intrusive to that person, and the problems appear made up or grossly exaggerated. Mrs. Sykes was also found to lack capacity because of her inability to retain information due to her dementia. The third element of the capacity test is the ability to use or weigh information. So for someone to have capacity, they must have the ability to weigh up information and use it to arrive at a decision. Sometimes people can understand information, but an impairment or disturbance stops them using it. In other cases, the impairment or disturbance leads a person to making a decision without understanding or using information that they've been given by the professional. A pre-Mental Capacity Act case, Ray MB, sets this out well in the context of healthcare. Following a medical examination, MB was pregnant, was informed that a caesarean delivery might be required. She consented to the operation, but then refused to be given anaesthesia by injection because she had a phobia of needles. When she went into labour, the hospital treating her obtained a declaration that it would be lawful for doctors, if they deemed it necessary, to perform a caesarean section upon her, which could include the use of needles to administer anaesthesia, because she was incapable of consenting to or refusing treatment. She appealed against the decision, and the Court of Appeal held that a person didn't have capacity where an impairment of mental functioning made them unable to decide whether consent should be given. This could be due, in urgent cases, to temporary factors, including panic brought on by fear, and that could completely erode capacity. A person is unable to use information and weight in the balance as part of the process of arriving at a decision, where one object may be so forced upon the attention of the individual as to shut out all others that might require consideration. In this case, the needle phobia drove out any consideration of other risks or concern to herself or to her unborn child, and the court held that she lacked capacity. Using or weighing information as part of the process of making a decision is an essential third element of the functional test. But as assessors, you have to recognise that different individuals may give different weight to different factors. You have to beware of conflating an assessment of the weighing up process with an analysis of the person's best interests. Remember, a person doesn't have to take account of their best interests when making a decision. You also have to be satisfied as an assessor that the person has had relevant information that they can use to weigh or use in their decision making. So you need to be clear what the information is and how it's said to be relevant to the decision. This aspect of the test has been described as the capacity actually to engage in the decision-making process itself and be able to see the various parts of the argument and to relate the one to the other. It isn't necessary for a person to use and weigh every detail of the options available to them in order to demonstrate capacity, merely the salient factors. Even though a person may be unable to use or weigh some information relevant to a decision, they may nonetheless be able to use and weigh other elements sufficiently to be able to make a decision. It's interesting that the statutory requirement is that the person must be unable to use or weigh relevant information. In practice, the two terms are usually used together rather than disjunctively. So we also refer to using and weighing rather than using or weighing information. It's clear that the person should be considered to lack capacity if they are unable to use information or unable to weigh information. As assessors, you do need to be cautious of the dangers of equating an irrational decision with an inability to make one. Irrationality is value laden. It is irrational to you, but maybe not to the person. The person may not agree with the advice of professionals, but that doesn't mean that they're being irrational or that they lack capacity to make a decision. If a person is able to use and weigh relevant information, the weight to be attached to that information is for the person themselves, not for you. So be careful when assessing a person's capacity to make sure that you're not conflating the way in which they apply their own values and outlook, which may be very different to yours, with a functional inability to use or weigh information. This means that as much as possible, you need as part of your assessment with the person to glean an idea of their values, their life story as it relates to the question. In some cases, it may be difficult to identify whether the person is using a piece of relevant information, but according it no weight, or failing to use a piece of information at all. It might be that you need the assistance of a psychologist or a psychiatrist in such cases. The code of practice reminds us, and the statutory provision seems to imply, that capacity is decision specific, a material matter at the relevant time. So capacity is also time specific. But this can give problems where the person's capacity appears to. The code of practice says, as in any other situation, an assessment must only examine a person's capacity to make a particular decision when it needs to be made. So the code's view is decision and time specific. Their advice is to put off the decision until the person has the capacity to make it. Interestingly, the approach in the deprivation of liberty safeguards code of practice takes a different view depending on where the person is within the safeguard system. So whilst the code of practice doesn't provide guidance on how to deal with fluctuating capacity at the initial authorization stage, the DOLS code of practice focuses on fluctuating capacity during an authorization. Here they say a balance needs to be struck between the need to review and terminate an authorization if a person regains capacity, and spending time and resources constantly reviewing, terminating, and then seeking fresh deprivation of liberty authorizations as the relevant person's capacity changes. So where a person is subject to a deprivation of liberty safeguard and their capacity fluctuates, the advice of the code of practice is to take a more longitudinal view of it. Is this return of capacity a permanent state of affairs that would render the safeguard null and void? Otherwise, it isn't practical for you to say, oh, they have capacity today, end DOLS, they lack it tomorrow, reinstate the DOLS. So they do seek a more longitudinal view. They take the opposite view, or the courts at least took the opposite view, in X and a local authority in 2014, where a retired drunk barrister was placed in a care home because of his excessive drinking and was subject to a safeguard. Now, off the alcohol and having support, his capacity seemed to improve, and he was subject to review. The care home felt that his capacity fluctuated. But when the assessors came to do the assessment, they rightly, in the view of the court, adopted a decision-specific and time-specific approach. That when they assessed that person at that particular time, a time that had been suggested by the care home as being a time when the person was probably most alert and at their best, as they're required to do under the code of practice, the assessor felt that he had capacity. The judge accepted this and said that the assessor had acted properly. The person had capacity, so didn't meet one of the key requirements for authorizing a deprivation of liberty. So the case illustrates that there seems to be two approaches to fluctuating capacity, depending on whether it's part of the application process, in which case it's a decision and time specific issue, or whether the person is already subject to a standard authorization, in which case they recommend taking a more longitudinal view of the return and restoration of capacity. The final isolated requirement of a capacity assessment would be where a person was unable to communicate their view in any way. Sometimes there is no way for a person to communicate. It applies to very few people, but it does include people who are unconscious and in a coma, or those with very rare conditions, sometimes known as locked-in syndromes, who are conscious but can't speak or move at all. Where you have a concern about a person's ability to express their decision, it's important to make all practical and appropriate efforts to help the person communicate through the use of specialists. It might be that their behaviour indicates their ability to communicate a decision. So it is important that before deciding a person truly cannot communicate in any way, that you involve speech and language therapists, specialists in nonverbal communication, and other professionals. Essex County Council and RF is a classic case of what can go wrong if you do not assess capacity by applying the functional test properly. The court concluded that the elements of Section 3 were not set out in the report of the capacity assessor. The requirements of Section 3 were not set out in the mental capacity assessor's report in sufficient detail to rebut the presumption of capacity. That is the onus on you as an assessor. Are you able to rebut the presumption, and do you have evidence to support your rebuttal of that presumption? The assessment of the person's ability to retain, use and weigh information was unclear. There were no records of the person's wishes and feelings, and the Mental Capacity Act requires a person to be permitted and encouraged to participate in any act done for him or decision made affecting them. That had not occurred, despite the person expressing a consistent wish to return home ever since his placement at the care home. The upshot of this case was damages of some £80,000 and the return of a year's worth of nursing home fees and a further £50,000 in legal fees.